saw him on the docket. Seem to have, let me see here.
It's not one of those laying down to your left. Is it, Judge?
What's the full last name of your client, Mr.
Rosales
Benacourt?
Rio.
Thank you. That's what
I didn't see it on the docket, but I saw it on the court system. It was scheduled for today.
Is he a prisoner?
the only Carrillo I have is a Carrillo Barajas.
9072643.
I'm gonna pull that up.
I don't mind saying, I don't mind waiting.
That matter, Mr. Betancourt, the 907264433 is a case that's been resolved, it looks like. Let me see what we have here.
And that's correct, Your Honor. Speaking of Mr. Rio, I believe that it was for failure to do work crew, but for some reason my name was still attached to it.
And I see that it was what it's scheduled for today is not a hearing. It was for a review of work crew. He was supposed to call in and contact. Let's see. So I think he was not necessarily scheduled for a court hearing today, Mr. Betancourt. So you were appointed on that
I was
originally.
I wasn't asked if I could be released from that.
We'll remove you from the client, I think, or from the case as the attorney of record. It's a work crew requirement. So, all right. Thank you, Mr. Betancourt. And Mr. Rio, with regard to Mr. Rosales Carrillo, he was supposed to report for work crew. So they'll check that today and make a determination about whether or not he's in compliance and take an appropriate action based on that. Okay.
Thank you, Your Honor.
All right. Good morning, Mr. Johnson.
Maybe we call Mark Mendoza, please. XZ0363877. He's president of the court. He's going to sign this waiver and request a court date for October 20th. However, Mr. Rio would like to address conditions of release. It should be fulfilled already.
All right, I have the file is cause number XZ0363877. Mr. Rio,
Your Honor, I
Mr.
would.
Johnson is indicating you want to address conditions of release. Go ahead.
I do simply. The defendant has a new 37-mile-an-hour over speeding ticket out of Yakima District Court. So I'm going to ask the court to amend to add no speeding infractions as a condition of release. he continues to drive excessive speed.
And I would indicate on June 23rd, when he was here and this matter was continued today, I specifically did say no traffic violations or moving violations as a condition of release. So that is a condition of the release already,
Thank you.
Mr. Rio.
Thank you, Your Honor.
And I would indicate that that violation was a May 23, 2020, and he appeared on June 23. So I don't see any other moving violations since the last court date. But you do understand, Mr. Mendoza, the conditions of release here. Okay, you don't want a speeding ticket to land you in jail while this case is pending. Okay.
Understood, thank you.
All right, we're going to reset this matter today to October 20th. There's a waiver entered today. We'll provide you a copy of this. And that'll conclude your case. And you'll be free to go. Right, thank you, Mr. Johnson.
We get a copy. Yeah, no, we can do that. Thank you. And when the court's ready, if I'm pleased to make call Mr. Carter, Andrew Carter. That's 9Z08459929.
I have that file, and before the docket started, my bailiff handed me a report, a scram report, requested that I review this prior to the hearing. Mr. Rio, have you had a chance to either review this or discuss this with Mr. Johnson?
I have not, Judge.
All right, specifically, it pretty much, as far as I can tell, says that since September 24, 2019, Mr. Carter has been supervised on the scram program and the reporting no tamper events and no consumption events. Was there something else? I didn't see anything else in here, Mr. Johnson.
That's correct. And,
All right.
Just kind of preliminarily here, I want to make sure that the court has received the signed notice of substitution of counsel. This used to be this Lawrence case. Now,
Yes,
okay,
I do have that.
we are still waiting for discovery. So unfortunately, we don't really have much of a choice here. I'm going to ask for continuance. However, the reason I provided the information regarding the scram is to request an amendment for the conditions of release to allow him to remove the scram device and provide that he have an ignition interlock device, which he is ready, willing, and able to install. It's been almost a year here since he's had the scram device, a significant amount of time. And over the course of that time, he has showed strict compliance with the order of the court to not consume alcohol. And based upon that, we would ask that you amend those release conditions. I'm sure the court is well aware that the expense, not only the expense of this device, but also the restriction on your body. It's cumbersome, it's uncomfortable. And Mr. Carter has shown over the course of almost a year now that he's able and willing to comply with the order of the court. Given the amount of time, maybe this isn't an appropriate request if it's a month or two, but this is 11 months into this case. With that being said, we very much appreciate the opportunity. It's a significant decrease in the amount of money that is out of his pocket, so this case can continue forward.
Thank you. And Mr. Rio, were you able to hear Mr. Johnson?
I was, Judge.
All right, and what's the city's response to his request to basically substitute the ignition interlock device for the scram device?
First, I guess I just want to address one thing he said regarding discovery. We he just filed a notice of appearance on August 6th. I found out this morning he was unable to get discovery from Ms. Oren and then made that request to have it sent to him. So it is on its way. Regarding the Scram device, this is a pretty, the fact pattern here is pretty egregious as far as the city's concerned, but I think, a year of no hiccup should be rewarded. And so I'm not going to object to removal with ignition in it.
All right, with that record, Mr. Johnson, Mr. Carter, I'm going to modify the conditions of release here and authorize you to have a ignition interlock device put in place of the Scram device. All of the conditions will remain the same, and you can remove the Scram once the ignition interlock device is in place.
Very good, thank you. And Your Honor, I just wanted to make sure that Mr. Rio heard this. I didn't mean to imply that there was anything that Mr. Rio's office did incorrectly about discovery. I did make that request this morning, and he was very willing to accommodate the request. I just haven't been able to get anywhere with Ms. Oren's office with regard to discovery, so we have to go this other avenue.
All right, thank you for clarifying that, Mr. Johnson, in the information. I'll complete this amended conditions of release, and then I see you've also added forward a waiver continuing this matter to October 20th. We will enter the waiver and continue this matter, the pretrial, to October 20th. I've also signed a modified conditions of release or amended conditions of release. Make sure this. So remove the Scram once the ignition interlock is in place, okay? We just need to take a copy of these conditions of release in order to accomplish that, all right? Okay, thank you, gentlemen. This needs to go in that file. Thank you.
Call Christopher May, 9007455566. This is a request for continuance to the 27th of October. Spoke with Mr. Rio today about potential resolution. We had a very good conversation. I think we're making great strides for a resolution here, and hopefully we can get this done by that day.
And Mr. Rio, any objection to a continuance to October 27th?
No, Your Honor, I'm in agreement.
All right. We'll enter the waiver and continue this matter to October 27th.
My last matter is Mr. Rodriguez. XZ0406-841. It's an accusation of reckless driving. We're going to ask to continue that to the 27th of October as well. Spoke to Mr. Rio about this case as well, and I think we're making good progress on the resolution. Hopefully, we'll have it done by the 27th, along with this case.
All right, and I've been handed a waiver on Mr. Adrian Rodriguez continuing to October 27th. Mr. Rio, any objection?
No, I'm in agreement, Judge.
Thank you. And I'm just indicating on each form that you approved this verbally.
Thank you, Your Honor.
Sign that waiver. We'll continue this to October 27th.
Thank you very much, sir.
All right, thank you, Mr. Johnson. Ms. Mendoza, good morning.
Good morning, Your Honor. Judge, if we can call Alex Zamora Sanchez, please.
I have that matter.
Your Honor, I think the original court's copy might already be in the file.
Yes,
Your Honor, please could reset by agreement to October the 20th, and that includes a waiver of speedy trial. Mr. Rio, I can send your P copy via messenger if you'd like.
I think the court will do that for me. if I
yeah,
recall.
well, we can put it in the prosecutor's box here and they'll send it to them. I have a waiver. We'll enter the waiver and continue these two cases to October 20th pursuant to the agreement.
Thank you, Judge. Your next case, Mario Ramirez Mejia, please.
I have that, actually I have two files, is the other one. Infractions tracking, okay.
Sir, I'm asking if we could reset both cases to October the 13th by agreement with Anita.
We'll enter the waiver and continue these cases to October 13th. All right.
Next case is Osvaldo Salvador Derumen, please.
I have that file.
Your Honor, I'm asking to go to October 13th by agreement with the waiver.
And I do have a waiver. We'll enter the waiver and continue this case to October 13th pursuant to the agreement.
And
Thank you, Your
Your Honor, I have Feliciano Valdivia Fernandez on this morning as well.
I have that file.
Please agree, note, and agree FTA and reset this case to October 13th.
All right. Note the defense failure to appear. Will reset this to October 13th at your request without notice. I've made that notation.
Thank you, Your Honor.
All right.
That concludes all of my cases.
All right. Thank you, Ms. Mendoza. And we do have a couple of, looks like some pro se individuals. Mr. Zane Lane was here. He has applied for court-appointed counsel and requested a reset to be able to speak to him. We've reset this to October 13th at his request and provided notice to him. Mr. Libbert is appointed. Actually,
Thank you.
We just said the 13th. That should have been the 12th. Is that right?
That's my fault.
Yeah, so we'll need to send notice to Mr. Lane at his Richland address that October 12th is the correct date.
That's my fault, Your Honor.
All right, so let's make sure we get a notice to Mr. Libbert and Mr. Lane regarding that correct date. And we have Miguel Martinez, who's also pro se, applied for court-appointed counsel. Mr. Scott has been appointed based on his application. This matter indicates it was reset to the 13th. This should actually be October 12th. So we'll send notice to Mr. Martinez as well. That corrected date. All right. I do have some other matters here as well with documents. So I'll just go down the list in the order that I have them here. Mr. Rio, you can
Thank
stop me if you have any comments regarding any of these cases today. Lenny Fairley. Mr. Holt has filed a request to reset this to November 9th with a waiver. We'll enter the waiver and continue this to November 9th.
Thank you, Your Honor.
I think that should have been November 10th. Yes. Let's send notice to Mr. Holt that that date should be a November 10th date rather than a November 9th. Cesar Palomino Diaz. We have received a notice of appearance from Mr. Hanson as well as a waiver request and reset this to October 20th. We'll enter the waiver and continue this matter to October 20th. Adrian Medina. I have a waiver from Mr. Jones requesting to reset this matter to October 13th. We'll enter the waiver and continue this matter to October 13th. John Sibelian. Of a waiver presented by Mr. Jones. Requesting to reset this to October 13th. This and the accompanying infraction. We'll enter the waiver and continue these to October 13th. George Rodriguez has requested this matter be reset to October 13th in order for him to retain counsel. So at his request, we'll reset this to October 13th. He was present and signed or was served a copy of the new court date. All right, and those are all the cases that I have information on. So I'm going to go ahead and just call from the top of the docket, Mr. Rio.
Thank you, Your Honor.
Oh, I take that back. I have Carlos Carrillo Barajas. He requests some additional time to hire an attorney. This matter is reset to October 13th. At the defendant's request. Jose Cruz Pablo. This is an SOC compliance hearing. Mr. Villarreal represents, let's see. I think we have, this was entered on August 25, August 20th, reset to today's date for review. Since that time, Mr. Cruz Pablo has have to look at the dates here since he has a subsequent conviction for driving while suspended in the 3rd degree, amended from a 2nd degree. He's entered another deferred on a simple assault. He has a pending driving while license suspended in the 2nd degree in Franklin County. He has a pending destruction of property and simple assault in this court. Any communication at all with Mr. Villarreal?
No, Your Honor. City's going to ask the court to note the FTA and issue a bench warrant.
For the record, this is during the time when I have specifically indicated to each individual to make note of their dates. They don't receive any new notices based on the number of subsequent violations. His failure to appear here today. Issue a bench warrant, $500 cash or bond. Rachel Ivy.
You know, that's one where Mr. Roach, I think he plans to be there here in the near future.
Today.
Yes.
He's coming back. They're coming back.
He was on his way to Walla Walla and he thought he'd be back by about 10 o'clock-ish.
All right, we'll set a couple of his down. Of William Perez. This matter set for a pretrial hearing today. He did sign he was served a conditions of release on July 30th, at which time he entered a plea of not guilty, indicating he would retain counsel. There's no one in the courtroom. There's no one in the hall either. Mr. Green checked earlier.
He has an
Oh,
active
that-
warrant as well, Your Honor.
Thank you. He has a warrant out of Ritzville for similar charges. Issue a bench warrant. He posted bail, forfeit the bail, $1,500. I have Juan Regalado Luciano. There's no, and again, there's no one in the courtroom. Mr. Regalado Luciano is represented by Mr. Ramirez. Any contact with Mr. Ramirez, Mr. Rio?
No, Your Honor. I'm just going to ask you to note the FTA and reset this one time, please.
We'll reset it and send notice specifically to Mr. Ramirez. The address that we had for Mr. Regalado is not a valid address. It was, notices were returned from the Pasco address that we have. So we'll note the FTA and we'll reset this to, let's go out to October 27th. Send notice to Mr. Ramirez. We have Baltasar Torres. He was here today, requested additional time to be able to hire an attorney. Signed a promise to appear on October 13th. Reset this matter to October 13th. Looks like the balance of the cases I have on the docket for this morning are Mr. Roach's. We do have two no contact order reviews at 11 o'clock. Suppose we can take a recess until Mr. Roach arrives or until Mr. Huey arrives and the in custody as well. I do have
Mr.
one,
Roach.
Pardon me.
Mr. Roach just said he's pulling into the parking lot, so he'll, about the time we're ready to do the other things, he should be ready.
All right. And I would just note for you, Mr. Rio, there is an individual in custody today. I think it's Mr. Luis Nemesio. That was the juvenile. He was arrested yesterday on the violation of conditions of release. And Mr. Scott yesterday indicated that he was going to ask to enter a deferred prosecution. Apparently, Mr. Nemesio did meet with probation yesterday before he was taken into custody. I haven't seen any paperwork yet, though. So just so
Okay.
you're aware of where that stands.
All right, thank you.
So we'll go off the record until Mr. Roach comes in, so we can be in recess. And
Thank
are
you.
you going to need some time to speak to him, Mr. Rio, or are we going to be ready to go when he comes in?
It should be pretty quick. We actually spoke before court this morning, so
All
we
right.
have things ready to go.
All right.
I guess I should say thank you again, Judge, for giving me the opportunity to appear remotely this morning.
Well, I'm glad we were able to work things out. This went rather smoothly considering, so.
Yes.
It does open up one area of concern, so I'm going to have to talk to our IT. We're going to have to figure out a way to link in the sound system with Zoom so that people can participate if there's. Did you have any trouble? I guess I should ask you. Did you have any trouble hearing the attorneys when they were speaking?
For the most part, I could hear them once in a while. They would like step away or do something, and then I had trouble. But other than that, I heard most of what they said.
All right. So if they stay close enough to the microphone, maybe we'll be good.
I think
Okay.
so.
I'll make sure I pay attention to that in the future, should this need arise again. I hear the back door here, and Mr. Roach is coming into the courtroom. Good morning, Mr. Roach. Do you need any more time? Mr. Rio did indicate you spoke to him this morning, so are you ready just to proceed? Okay.
Just look at the calendar, or if you want to just call the cases that you have.
I can do that as well. So we'll go ahead and go on. We on the record? All right, we're back on the record. Mr. Roach has arrived. Mr. Rio, again, is appearing remotely. We'll call the first case of Mr. Roach is Rachel Ivy.
Yes, Your Honor. And I talked to Mr. Rio about this case, and my understanding was that this was on today for some sort of fine review, but he indicated to me that had already been accomplished potentially by this court, and that this was some sort of pre-design status conference. Mr. Jones was here earlier while I was in Walla Walla and scanned the hallway. She was not present, apparently.
I would just say, Mr. Roach, that this was the 2-year review date scheduled at the time this was entered on August 24th, 2018. Probation is not in here, but I don't see a report from probation indicating that there's been any violations. So I'm assuming, given the lack of any negative reports, that she's in compliance.
And that's the best of my knowledge too, Your Honor. I mean, I haven't heard anything negative about her in these 2 years since we finally entered this thing. So I'd ask her to strike it if that works. And I know she's had recent contact with you and your department because of that fine issue that I think you've already resolved. So with that said, I just ask maybe that we strike it.
Mr. Rio, any objection just to striking this? I really think it was a review to make sure she was in compliance, and I don't see any reports of non-compliance at this time.
Nor do I, Judge, so I'm okay with striking it.
All right, we'll strike this. She's in compliance.
Thanks, Commissioner.
Santana Marquez Alvarado.
Your Honor, this is a relatively new case of mine. I'm still getting some shape on the discovery. I asked that I presume safely that he was here and Mr. Jones basically accounted for our clients and then cut them loose, knowing that there's going to be lag time between him going to Superior Court and me going back to Wall. So
I do not see any reports here that he was present or any documents signed or submitted by Mr. Jones indicating that there's an agreed reset.
that's, so Mr. Jones had his clients, I think two of his clients signed. I just told Mr. Jones that as long as my clients were there, that we could cut them loose and I'll sign on their behalf and bring them notice. That was kind of a judgment call on my part, but I don't know if they're confirming right now whether or not he responded to roll call.
No, I didn't talk to Mr. Jones other than
Okay.
good morning.
I'm gonna ask, Your Honor, I didn't get any indication that this client was not here. But, I mean, for the record's sake, we can know his FTA. And then I just asked to set this out to someone probably, honestly, in the first or second or so week of November.
November 3rd or November 10th.
Might as well go to the 10th, Judge. Oh.
Mr. Rio, any objection?
No objection, Your Honor.
We will note that Mr. Marquez was not present today and reset this on your request, Mr. Roach, to November 10th without notice.
Thank you.
And Jonathan Reed,
He was not present, Your Honor, and we're gonna note his FTA. I did speak with Mr. Rio about this case. This was a multiple trial setting, a type scenario before COVID. He hails from Texas. And it looks like we got an agreement to resolve it. And he expressed some direct concern about traveling during COVID. And Mr. Rio and I talked about the potential of him doing this remotely. I can't debate what Mr. Rio remoting in on right now. If we can work out the logistics of that, I think we can get this settled in the next 2 or 3 weeks or whatever. So I just asked for a date that looks convenient to the court in terms of the numbers. I mean, I'm looking at your most recent printout of the caseload.
go September 22nd.
Sure, that'd be great.
Are you going to want to do this remotely?
I think so, Your Honor.
What we might want to do is set it for a docket that been choosing to do. If we can do the remote hearings on a different docket, I'd rather do that because what happens sometimes is we get some delays on other things. And in the past, people have been online waiting for an hour and a half or 2 hours for their cases to be called. We typically have been doing these on the Wednesday mornings that we've reserved for jury trials, but we're not doing any jury trials in September. So let me take a look at those dockets and see where we're at.
And, just to confirm, Your Honor, for the next cases that we call, I did get word back from Mr. Jones right now. The folks that were in the hallway that we cut loose were Trevino and Santana.
All right.
So, he was present, but we'll notice that TA for.
Thank you. And for Mr. Reed, we could set this as early as September 2nd or September 16th
I would prefer the
for
16th.
remote hearing.
Yes, please. The 16th would be great. And there'll be purpose behind this hearing. It'll be for a change of plea to an amendment, and we'll get it all done on that date. That gives me time to talk to him and go over the forms with him too. And Judge, I guess not to take too much more of your time, but logistically, I know we've been doing this quite a bit over in Benton County, and I just asked if, for instance, let's just say this week I talked to Mr. Reed, I know he's going to confirm the resolution agreeable to him. Then the question becomes, can I have him electronically sign documents, send them back to me, and I present the original PDFs to you?
I don't have any objection to that, Mr. Rio. Any
No, Judge,
objections?
I would hope that he could appear via Zoom so that we actually have someone that we can see. That would be.
All
my
right.
request.
That's no problem, yeah.
All right, and I think two things, it sometimes gets overlooked when we send out the instructions, but for arraignments and change of pleas, I prefer individuals appear on via video as not just telephonically, so,
Understood.
and attorneys are required to appear via video as well, so you'll be here, my understanding is you'll be here on September 16th with the documents to submit, and Mr. Reed will appear via Zoom.
That's correct. I'll be in front
Okay.
of the court. Yes, that's my, the only thing I can tell you is on the 16th, I also, if I come over here and do this docket first, I can either have Mr. Jones cover it, and his Wednesday morning dockets or the state control chaos dockets. But
Yes.
I'll make sure that I am here in person on the 16th to finish Mr. Reed's case.
All right. The alternative is a Friday setting. We've set some remote hearings on Friday. I'm just not sure what are.
I defer to the city. I could do either way. I'm okay with the 16th, right? Mr.
I think the
Reed?
16th should work, Judge.
The 16th? All right, we'll reset this for a remote hearing on September 16th, and we'll send the instructions to you, Mr. Roach,
Yes.
so that you, and you can forward those to your client and talk to him about how to connect
Will do that.
remotely. All right.
Thanks, Judge.
And I have Belen Trevino.
Yeah, he was present out in the hallway. We excused him. We're gonna ask to notice that for his speedy trial purposes. But this is a blood draw case. We're still waiting for the results on it, and he's got a corresponding felony that's been reset down about a month or so from now. If I remember correctly. So I'd ask to set this maybe to like, I don't know, for the time being, October 27th and November 3rd. Does that work, Mr. Rio?
Yes.
Yeah, so either.
Is there a preference for either one, gentlemen?
No.
No.
October 27th.
Great.
We'll reset these two cases to that date without notice.
Thank you, Judge.
And then Edwin Watt.
Mr. Jones did not confirm that he was present here at one point or another this morning, but I'd ask to note his estimation as well. We do have discovery completed at this point. It was a blood draw case that took a while to get. And he and I have to meet and go over the documents here at this point. So I asked to set this to either October 27th or November 3rd as well. Part of this is getting an evaluation, Judge, and we haven't done that up to this point, but now that we've got everything, I think that's probably an appropriate thing for him to do pre-trial and determine where we're at. But I say this, I don't want to not advocate for my client. He's been in court regularly. He was very cold that he showed up. I don't know if he got a mixed message about today or not, but Mr. Jones did not talk to him in the hallway to the best of my knowledge.
I'm okay with resetting it, Judge.
All right, and I do show no new violations and no prior failure to appears here, so we'll reset at your request to October 27th.
Thank you, sir.
It's without notice. All right, Mr. Roach, I think that's all I have for,
Sorry about the time,
You
Judge.
today.
Yeah.
yeah, you arrived just 5 minutes after we finished the other cases, so it's all good.
I'll tell you that I witnessed something happen while on district court that I'll give you some facts about off the record at some point. It caused some delay and it was very on the part of one of my fellow practitioners was very poor form on his part that kind of offended the whole entire courtroom for a little while. So there was some drama over there.
We can go off the record, yeah.
Yeah, well, Mr. Rio should hear this too. Not that I should probably poison the well too much, but that St. George guy, or George is his last name or whatever. I hadn't had a memory of this feeling for probably about 20 years, where your mouth gets all chalky and you tense up and you feel like you're about ready to fight somebody. But he was picking on this Michelle Morales, who's the prosecutor up there. She's a pleasant, hold her ground type gal, but real reasonable and decent to deal with. And he, before the judge came in, was to the point where I thought he was going to swing at her. He was so utterly offensive. And then he came up to me right afterwards. He stormed off before the judge got in, and then came back and started lashing into her again. And then came over to me and started asking me for some sort of weird motion hearing, idea. And I looked at this John Hartzell, who was a cool, neat, decent guy, and I said, what is up with this guy right in front of his face? But it was to the point where, I think she should take action against this guy. And I rarely say that, but that's how much I think of this dude. He is he was so ruthless to her, picking on a woman like that.
I don't think we've had him here. I don't recall seeing him, so.
Yeah. Absolutely. But you've dealt with him, right, Mike?
No, but you're making me nervous, in case I ever have to.
Yeah. Oh, I would have loved for it to have been you. That would have been fun. And he did the same thing to Josh Lilly about 2 or 3 months ago. And I stood by and kind of watched that one. And of course, Josh just stood right up. And, he's sitting in her chair. And he's like,
Is he in Benton County or something, or is
when he does appear here, which he would. My understanding is he lost his license for a while, came back, and it had to do with mental health. And so he's practicing, he told me today, he's like in Soton, Benton, Walla Walla, and so he's kind of making this circuit. But I watched him come in to Josh one day in Benton and say something on like a .29 accident, first offense, blood draw with some prescription meds on board too, and a client that was really compromised. And he just berates Josh for not giving him an A. And just like you have no context of any, and they just got this, he's like, well, if you're not gonna give me anything, then I'm gonna file all these motions, blah, blah, blah. And Josh was just like, whatever, dude.
do what you need to do?
Anyway, it was
Yeah.
pretty pathetic, I'll be honest. But I'll see you guys a little bit. I don't know if we have docket stuff tomorrow.
No.
Okay,
Oh.
If you have this gentleman, I handed it up a little bit ago from the defense attorney. Thank you.
Yeah. All right.
all right, James.
All right. Thank you, Mr. Roach. All right, Mr. Rio, I'm going to take a short break, and when they're ready to go on the in custodies or the no contact order reviews, we'll come in and get started again.
I'll be here. Thank you.
Have you had a chance to review the no contact order stuff?
I have, Judge. Yep.
All right. All right. Okay, we'll see you in a bit.
All right. Thank you. How's it sound now, Phil? Is it pretty much just my voice and nothing else? Okay, thanks.
Right, let me get my calendar here. We do have some matters that were scheduled for 11 o'clock for the no contact review. Let me take a look at those first. Mr. Jameson, you're here on Mr. Lorenzo Valle.
I'd like to make a brief summary of the record I did provide your honor in the letter that
And Mr. Jameson, I'm going to ask you to make sure you speak loud enough to the microphone there so Mr. Rio can hear what you're saying. Just for the record, we are here today on Pasco Municipal Court. It is August 25, 2020. Mr. Rio is appearing remotely for this hearing. We do have Mr. Jameson in the courtroom, as well as Mr. Ovalle, and Ms. Rocio Martinez is present as well.
Yes,
All right.
That's correct, Your Honor. Again, for the record, I'm taking up what would be Mr. Rio's spot here at council table, but Mr. Rio doesn't have the benefit of seeing the letter that I provided for court this morning, because I didn't know that he would be physically present, but also Mr. Valle provided that letter to me this morning, and in summary, their counselor is recommending essentially what I would assume most counselors at some point would do, and that is that these parties have worked together under the amended no contact order at counseling on their issues, relationship issues, other things, but my client also completed anger management. And effectively what the letter is indicating is that it's time to reunify these parties so that they can work on the tools and skills they've learned through counseling, couples counseling, as well as Mr. Valley's anger management, that they be allowed to go home, so to speak, and work on those things at home. Like, again, I would assume any counselor would want the parties to take the tools that they've learned and continue to work on them in a private home environment. So at this point, we're asking Your Honor to consider terminating no contact order so that they can continue with their counseling and work on those things at home. And I think the letter, again, Mr. Bria doesn't have the benefit of seeing it yet, but Your Honor has seen it, and effectively that counselor says he's comfortable with the parties being back in the home environment together.
And Mr. Rio, for your benefit, I have been handed a copy of a certificate of completion on behalf of Mr. Lorenzo Valle of the Anger Management Treatment Program. I've also been handed a copy of a letter from Valdez and Associates indicating pretty much what Mr. Jameson has put on the record here this morning.
What's the date of that letter, Your Honor?
August 24th.
Thank you.
And on behalf, Ms. Martinez is present in the courtroom, and I have read your petition to rescind the no contact order in this case. And as I tell any number of individuals who enter into these agreements, the decision whether to terminate a requirement of this agreement is pretty much up to the city prosecutor, in that one of the conditions of the stipulated order of continuance was that he comply with the no contact order. I would say that this is the first or one of the few times I've had somebody come back and file proof of completion of an anger management program.
Your Honor, I had Ms. Martinez step up in my location in case you wanted her voice on the record closer.
Thank you. Mr. Rio, what's the city's position regarding this no contact order?
Well, unfortunately, Your Honor, on July 30th, Mr. Uvalle has a new violation of court order. He and the protected party were in a motor vehicle together, and he has now been charged with that violation of court order in Franklin County District Court. While I appreciate that he's done anger management, that new violation is something that I can't overlook. It's going to be the reason that the city's going to move to revoke this SOC at some point in the near future. And so I'm going to ask the court to deny the request. We just got a month now since a violation of the court order.
Your Honor, if you'd like, I've spoken with Mr. Chow, the prosecutor on that case, and we have an offer of an SOC on that case, if that helps the court in any way that de minimis, again, is alleged at this point, but I'm told that the parties were discussing the next steps were to be in counseling. So again, it's difficult that they're allowed to talk and see each other at counseling, but not away from that. I think that's where the point is now, that the counselors are to a point where they're, I won't speak for them, but I'd say at a dead end, without these parties being able to be back together, there's not much more to work on or do in terms of a relationship. And so, yeah, I don't dispute that there is a new charge, which may be grounds for revoking SOC, but nonetheless, I could show you, but take my word that the written offer from Mr. Chow is for an SOC on that case. And I, again, must be because of the de minimis nature of the violation. So we don't downplay it as an alleged violation. But to not repeat myself too much, I think these parties are at a point where they can't work on anything further as the counselors would like them to do without being able to be together.
We are also seeing a second council as well online. We are in our third session.
You may have heard my client, Your Honor, they have some online third session of additional counseling that they're working on.
Well, and if the court wants to modify the order to allow them to attend online counseling and only have contact with the counselor, I'm not as opposed to that as I am to removing the whole of the no contact order.
I'm just reviewing the affidavit of probable cause in relation to the July 30th violation. I do know in January, I modified the no contact order to allow contact electronically to arrange and then also to attend counseling. I see that according to this, their letter, there were looks like 3 counseling sessions participated in with regard to the defendant and the protected property.
In the past, and we're trying to stop with all the coronavirus.
I think what my client's saying, Your Honor, is they had been seeing him prior to COVID hitting, and then everybody shutting down. They were unable to do much more than online, but now recently been able to get back in person.
States in there that he has seen us in the past.
So I think the 3 live sessions that counselor is referring to are of recent due to, again, opening back up partially due to COVID.
And I'm not going to file this letter because it is basically a medical document. I'm going to return this. If you want to provide copies to Mr. Rio, you can do that.
I will certainly do that, Your Honor, since I just received it this morning. I'll have my staff scan it and go into that.
But I will indicate, as I did previously, these agreed orders continuance are a little bit different than situations where a person has been either before the court and a hearing is pending, or a judgment and sentence has been entered in as part of the judgment and sentence. The defendant has been ordered to comply with the no contact order. In this particular case, as I said, this is an agreement between the parties that the defendant would abide by the no contact order. It is, although I commend you for going to treatment, according to that letter, there's 3 meetings have been held, and the counselor expresses the opinion that it's time to reunify the family. That's not the only thing that I can consider here. There's an agreement between the defendant and the prosecutor regarding the no contact order as part of a stipulated order of continuance. And with the one party of the contract objecting to the removal of that, condition, I don't think I have an alternative but to leave it in place, simply because that's the contract that was entered into between the parties at this time. So even though if this was a different set of circumstances where somebody had moved forward and done the anger management or completed some counseling, I might be inclined to make some other decision under this particular case, because it's still pending under that agreement with the city prosecutor's office and them objecting or opposing that. I'm in a position where I'm going to deny the request to remove the no contact order at this place.
Did our family a lot. I would like you to consider, we're trying really hard. We're doing everything.
Ms. Martinez, maybe Mr. Jameson can explain this, but this is an agreement between Mr. Uvalle and the prosecuting attorney's office.
We're talking about.
We were literally talking about counseling, Your Honor.
As I said, be quiet and sit down. As I said, we're talking about a contract agreement here. Under the terms of this contract, that an agreement you entered into there, and the one party objecting to the removal of a term of the contract, I don't think I have a choice under. No. Mr. Uvalle, I didn't force you to enter into this agreement, okay? I specifically told you at the beginning of entering this agreement that it is an agreement between you and the prosecuting attorney's office. It is a contract. You'll be required to follow the conditions of that contract. Perhaps Mr. Jameson can make some inroads with Mr. Rio, but under the terms of this agreement, I don't have any alternative except not to deny the request at this time.
Your Honor, if I may, could we request just a 1 week or 2 week before? I know we're gonna have dockets and things. The reason I say that is that we've got court tomorrow and Thursday, 3 days in a row here. We may have a resolution of the Franklin County case. And then at that point, maybe Mr. Rio and I can talk about whether this is going to get revoked. And if it does, what Your Honor, what the agreement will be. But again, I wasn't counsel of record for the entrance of the SOC, so obviously would like to work towards getting this no contact order terminated for these parties, but also resolve the Franklin County case and figure out what's going to happen on this particular case, whether it's revocation.
And so what are you asking for, Mr. Jameson?
1 or 2 weeks if you'll allow, because like I said, we have court tomorrow and Thursday, so we'll have better direction, but if dockets are too heavy, of course I understand what 1 week or 2 weeks looks like. I don't know.
We have one case set for review next Tuesday. I'll set this over 1 week at your request and give you an opportunity to talk to Mr. Rio, forward information to him, and we'll address this next Tuesday at 11 o'clock. All right. Thank you. Is Marta Sierra present? All right, come forward, please, to the table with the microphone here next to the divider. Mr. Rio, have you had an opportunity to review the affidavit provided in this case?
I have, Your Honor.
All right. And for the record, I have reviewed the affidavit signed by you, Ms. Sierra. Is there any additional information you would like the court to consider? All right. And what is the city's position in this case, Mr. Rio?
Your Honor, this is a case from June 21st. The allegations are that the defendant threw a beer bottle while ripping the phone out of her hand. He ripped her earring out of her ear and left with the phone. At this point, the city's not in agreement to remove the order.
I have reviewed both the application or the request to rescind or terminate the no contact order, as well as the affidavit of probable cause. And Mr. Rio's response, the city does oppose this. This is a situation where the defendant actually, during part of this, indicated that he would kill the alleged victim if she ever left. There was a physical confrontation in which he not only took the phone and took any way for her to call or ask for assistance, but physically ripped an earring out of her ear at the time of this incident. Based on those facts, based on the fact that this is a pending charge as well, I'm going to deny the request to rescind the no contact order at this time. Order remains in place. Oh. Who's that on the back? In the back, the one who stand up speaking. Who is that? This Sacklicar.
Is there anything I can do?
Well, not while this case is pending. I don't believe so. No. He has to come to court. Yes, he has this criminal charge still pending. He's going to have to take care of this, I believe. Okay. The no contact order stays in place. Yes. Danielle Sacklicar. I have been handed a request or an order for a competency evaluation. Is it Mr. Huey? I'm going to have Mr. Huey come in. He spoke to you this morning.
I think if you look at his record, he has some previous 1077.
I wanted to know right now. I was.
Looks like there was last year there was a case that it doesn't say the basis for the dismissal.
The last year's past, I found not guilty in my home. The real version, I have the physics record. The alpha, I don't know what.
All right, thank you, Mr. Sacklicar. Based on the conduct here observed in the courtroom today, and it looks like the history, there's been a request for an evaluation. I'm going to sign the order for the evaluation. We'll set this to August 31 for the next hearing at 8:30. We'll appoint an attorney to represent as well. It looks like we appointed Mr. Scott already.
May I state or go my own personal time, please go home and come back at that time?
Mr. Sacklicar, until I have a report from the doctor, I'm not going to address conditions of release. All right. Thank you, sir. give him a copy of Mr. Scott's contact information. All right. Make sure he gets a copy of that. There's not going to be any conditions of release. He'll be held until the evaluation is concluded. Oh. All right. Thank you. Which one?
This one.
Oh, okay.
I'm standing in for Mr. Scott. If he was fine. I think Mr. Scott indicated that we already did get
Just Mr. Rio, you're going to make sure you need to stand in front of a microphone. Mr. Rio is appearing remotely. In order for him to hear you, we have to make sure that you're picked up by the court system, because the only transmission of your voice is through the speakers here as they pick up. So if you'll start again, please.
And I've been in conversation with Mr. Scott, indicates that he would like to enter the deferred prosecution day. He previously submitted our paperwork to the court. He qualifies for the deferred. He has already been attending classes. He's been attended 6 classes in the last 2 weeks. And I think that all the paperwork has been submitted and signed. So we've already qualified and everything. We'd also like to address the strands. He has strand appraisal on. It's accepted as the first prosecution program. We'd ask that
All right. Before we proceed to the consideration of the deferred prosecution, the reason we're here today is because a warrant was issued for Mr. Nemesio's arrest based on his allegation of a violation of conditions of release in this case. So in that regard, this was a motion made by the city. Mr. Rio?
Your Honor, I filed that motion. And so I just asked the court to review it. If the court's inclined to grant the deferred prosecution, obviously we can go forward with that. If you're not inclined to it, then I think we would go through with the hearing on the violation.
All right, thank you. Just a moment, please.
And the only thing I think you would need to also address, Judge, is whether you're going to order restitution on this case as part of the deferred prosecution.
I do have the paperwork that's been filed with and reviewed with the probation department. I will say this, just looking, Mr. Nemesio, at your history, you have a prior driving under the influence of intoxicant conviction from February 23, 2019. You have this subsequent violation that we're addressing here today, which was a hit and run unattended, driving while license suspended, and a driving under the influence. Since being placed or being required to be supervised for these, there's been 2 alleged violations of the scram that indicated an alcohol consumption event. Looks like there was one in April, there's another one in June, and then a 3rd violation in August, from August 16th through August 17th. I only raise those issues because, and if Mr. Scott were here, I would have this conversation with him. I mean, it doesn't seem like you're at the place where you're ready to participate in this type of program. You need to understand something. I'm not saying that I'm not going to grant this request. What I'm saying is that if you are allowed to enter this deferred prosecution, there is going to be strict compliance. I will not tolerate any missteps on this deferred prosecution. I mean, while you've been on release, you've had 3 allegations of violating conditions of release. I've issued warrants twice for your arrest, and you've been arrested. So there will not be any leniency or it was a mistake, it's not going to happen again. You need to understand that. You will be held strictly responsible for complying with this. Do you understand that? You have gone over these forms with the probation department. Have you reviewed them with Mr. Scott as well? You have provided what's called a declaration of non-driving status for the deferred prosecution. What that means is that you cannot drive a motor vehicle without the permission of this court. Do you understand that? And I hear that family members are in the courtroom today. They need to understand that as well. Because he's provided this declaration that he will not be driving, if there are any driving violations, he will be removed from this deferred prosecution program. Do you understand that? You understand that by petitioning the court for a deferred prosecution, you make the following statements. You do believe that these charges are a result of a substance abuse disorder. You believe that without treatment, there's a probability that you will have these types of problems in the future. You also agree to pay for the costs of diagnosis and treatment if you're able to do so. You also say that you believe you are not innocent of these charges and you need treatment, and that you've never done a deferred prosecution for a driving offense in the past. Is all of that correct? And you understand that? You understand that you have a number of rights today that you waive by petitioning this court for a deferred prosecution. You waive your right to a speedy trial and a jury trial. You waive your right to testify. You waive your right to call and question any witnesses or present any defenses. You are agreeing and you stipulate to the facts contained in the police report and agree that they are sufficient to support a finding of guilt in this case. Do you understand that? You also understand that if this is revoked, that you may be sentenced up to the maximum penalty allowed by law, which is 364 days in jail. You understand that? You understand that for a period of time on deferred prosecution, you may be required to have an ignition interlock device if you get a license. Do you understand that? You will be required to pay the costs of both probation and the deferred prosecution, as well as a $250 BAC assessment and $300 emergency response fund assessment. Do you understand that? You will be required to attend the DUI Victims Impact Panel. You will be required to have complete abstinence from any alcohol or non-prescribed mood-altering drugs. Do you understand that? During the period of this deferred prosecution, you cannot travel outside of the state of Washington. You understand that? You understand that if you successfully complete this program at the end of the 2 years of treatment and the 3 years of probation, this matter would be dismissed. You understand that? On the other hand, if this program or deferred prosecution is revoked, the only thing that happens is a judge reviews the police reports and makes a determination of either guilty or not guilty based on the reports and nothing else. Do you understand that? As a part of this condition of deferred prosecution, you must sign this release of information for the agency that you are attending. Where are you going to treatment, Mr. Nemesio?
I'm doing the test from right now.
Let's just sign this release, please. Actually, he may have to have an adult sign that release because he's only, yeah, he's only 17. Yes, please. I'm going to have him sign next to hers as well. All right, I do make a finding that Mr. Nemesio is eligible for treatment. That treatment is necessary, that he's met the requirements of the petition here, that the approved plan is attached here. He's stipulated to the facts and the admissibility of the police reports. He understands the rights, and he's done this knowingly and voluntarily. You do understand that you will not drive without a valid driver's license, proof of insurance, or an ignition interlock device. And specifically, you will not drive a motor vehicle without permission of this court while this declaration of non-driving status is in place. Mr. Rio, you're asking for restitution in this case. Do we have an amount?
I don't have an amount right now, Judge. I can just ask that it be set to be determined, please.
All right. I will order as part of this deferred prosecution that restitution be paid. And we will set a hearing within, say, the next 60 days to determine that amount.
Yes, Your
Mr.
Honor.
Rio? Okay.
Yes.
In fact, actually, I think, why don't we set the hearing today for, we can even do it at the March 1st, 2021 review date. Is that too far out?
I will, if I need to set it sooner, I will, Judge.
Okay. There is a review date set for March 1st, 2021, a 2-year review date on September 12th, 2022, and an August 25th, 2025, 5-year review date. I'm going to sign the order granting the deferred prosecution. There are a number of infractions that were issued along with this: a violation of restricted license, a speed too fast for conditions, and an operating a motor vehicle without proof of insurance. Those are on the docket today as well, because they have been trailing this criminal case.
City's normal motion on that, dismiss everything but the no insurance ticket, please.
Very well. So I will dismiss count 1 and 2 based on that, which is the violation of the license restriction and the speed too fast. With regard to insurance, Mr. Nemesio, you have a right to have a hearing on that, or you can take care of this today. There are 2 options. You can admit the violation and we can talk about the amount of the penalty, or if you believe that you had insurance that would cover you at the time, we can set this down the road and you can provide proof of insurance. Or if you want the city to prove that you drove without proof of insurance, we can set this matter for a contested hearing. What would you like to do today?
You think the car had insurance? It did? Would it cover you?
Set it for a hearing.
Yeah, that's for a
This is case number XZ0241128. So I have dismissed counts 1 and 2, but we'll set the insurance violation for a hearing. Let's see. Did we lose Mr. Rio? Let's set this actually on the pre-hearing conference docket. Make sure Mr. Rio is involved on September 17th, please, at 8:45 in the morning. Mr. Rio, we lost you for a moment. Are you back and able to hear me?
I am, Judge.
All
Sorry.
right. With regard to that insurance violation, because this is a deferred prosecution, I'm going to go ahead and set this on a pre-hearing conference docket of September 17th, just so you're aware and involved as well.
Thank you.
You do have an appointment with probation on September 1 at 2 o'clock. That is a, looks like a call-in appointment. We'll give you a copy of that today. Yeah, said that's fine. Just like at 8:30. Yeah. Yes. Yes. Right. I've signed the order granting the deferred prosecution. Need a time pay. Pardon me? Yes. The costs associated with the deferred prosecution and court-appointed counsel, the BAC assessment and the emergency response fund assessment was $1,740. I'll set those. At $50 a month, beginning on September 25. I have signed the order granting the deferred prosecution. That information will be forwarded to Mr. Scott, and you can receive copies from him. We will give you copies of the costs associated with this, the time pay agreement. And your next appointment with probation. Do you have any questions, Mr. Nemesio?
I think the only other issue is, would you allow it if they would? Yeah, there is gonna automatically be a requirement.
Yes. And I will authorize the removal of the scram in this case. I'll give you a separate order indicating that can be removed. All right. All right, that will conclude your case today, Mr. Nemesio. You can have a seat. Yes. All right, which interpreter? Yeah, interpreter case. Let's. Thank you. Josue Sepulveda Zuniga? No?
It's Mercado and
Isaac Mercado Zamora? All right. Sir, you're here today on a charge of simple assault domestic violence. That is a gross misdemeanor. If convicted of that, you do face up to 364 days in jail and a $5,000 fine. There is no mandatory minimum sentence for such a conviction. Do you understand that?
about the charge.
Yes. And the possible sentence?
Yes. The interpreter is having a hard time hearing the
All right.
defendant. Your
Let's not make copies anymore while the court's in session, please.
If the
You-
defendant could get closer to the mic, Your Honor.
Need to be sure you speak up so that the interpreter can hear what you're saying. Sir, you have a number of constitutional rights that were played in a video before court started. Were you able to hear and understand those rights?
Yes.
You have had a chance to talk to the provisional attorney. After doing so, he's indicated you wish to plead not guilty and request court-appointed counsel. I will enter a plea of not guilty on your behalf. We'll appoint Mr. Eric Scott to represent you. Looks like there was a prior failure to appear for arraignment, and bail is currently set in the amount of $1,000 cash or bond. Mr. Rio, conditions of release?
Your Honor, I'm going to ask the court to impose that he have no criminal law violations, that he appear for all court dates. I'm going to ask the court to impose a no contact order, which was requested by the victim. And I'm going to ask the court to leave bail at $1,000 bond or cash.
Mr. Huey? Yes.
So I don't think we knew about the court hearing. I was telling you the facts about the first time this happened over 2 months ago. He seemed surprised at all that. So we hope to take that into consideration. He's been in the Tri-Cities for the last 7 years. I told about the possibility of no contact order. You will find that no contact order. He has been to that in the area.
All right, I am going to issue the no contact order pursuant to the request of the alleged victim. This is a pretrial no contact order. It will expire on August 25, 2022. Only the court can modify or terminate the order. under the terms of this order, you're not to cause, attempt, or threaten to cause bodily injury to, assault, sexual assault, harass, stalk, or keep under surveillance the protected person. Do not contact the protected person, Lida Mercado, in person, directly, indirectly, through others, by phone, mail, or electronic means, except for the mailing or service of process of court documents through a third party or contact by your attorney. Do not knowingly enter, remain, or come within 500 feet of the protected person's residence, school, workplace, or person. This no contact order will expire on August 25, 2022. The court can extend the no contact order or terminate it, but only the court can do that. A violation of this order with actual notice of its terms is a criminal offense under Chapter 2650 RCW and will subject you to arrest. Any assault, drive-by, or reckless endangerment that is a violation of this order is a felony. You can be arrested if the person protected by this order invites or allows you to violate the order's prohibitions. You have the sole responsibility to avoid or refrain from violating the order's provisions. Only the court can change the order upon a written request. I'm making a finding that this did involve an intimate partner. I do see that this was a notice that was mailed to Mr. Mercado. I'm going to release you on the condition that you have no criminal violations or incidents. You have no domestic violence related incidents. You obey the no contact order. You are to contact your attorney within the next 10 days and then contact your attorney every week while this case is pending. I'm going to set this for a new court date. On September 28th. That's at 8:30 in the morning. I don't have a signature of an interpreter on the domestic violence no contact order, so I'll ask the interpreter to review this with him before he leaves court. Other than that, you can step down, Mr. Mercado. And how do you pronounce your name, sir?
My name?
Yes.
Crescencio Costa.
Koskawa? All right. Mr. Koskawa, you are here today on a charge of driving under the influence of intoxicants. That is a gross misdemeanor. If convicted of that, you do face up to 364 days in jail and a $5,000 fine. There is a mandatory minimum sentence of 1 day in jail if convicted of this. Do you understand that?
Yes.
You have had a chance to talk to the provisional attorney today. After doing so, you've indicated you wish to plead not guilty and you request the court appoint an attorney. I will enter a plea of not guilty on your behalf, find that you qualify for court-appointed counsel, and appoint Mr. Rutt to represent you in this case. I have reviewed the affidavit of probable cause, and I do find probable cause. Conditions of release.
I'm asked the court to impose that he have no criminal law violations, that he appear for all court dates, that he not drive without a valid license and insurance, not use, possess, or consume any alcohol or non-prescribed drugs. I don't see any history. I do have an issue. He's out of state, so that causes me some concern. I'll leave bail to you, whether that's enough of a concern to impose bail.
Mr. Huey?
Yes, Your Honor, he has been residing in Washington State for the last 2 months. He came here to work for a dairy farmer, and he doesn't plan on residing here going forward. He is from Oregon. He asked if he has a criminal record in the other state. He said no. So we're hoping that he'll be all right.
And you've been living in Mesa since, for the last 2 months?
Where you been living here? Right? That's what you told me. Where do you live?
En Mesa, Washington.
Mr. Kakawa, I will release you on the following conditions. You're not to have any criminal violations or incidents. You're not to drive without a license or insurance. You're not to possess or consume any alcohol, marijuana, or non-prescribed drugs. And you are to submit to a test if an officer requests such test and has a reasonable belief that you've consumed alcohol or drugs. You're to contact your attorney within the next 10 days and contact him every week while this case is pending. You're to make appropriate appointments with your attorney in order to assist him in representing you on this case. Your next court date is September 21, 2020. You need to bring with you at your next court date your actual address. Do you understand that, sir? It looks like there was an infraction that was issued along with this. Usually you would have to respond to those separately, but because you are here today, I'd ask you if you want to set that infraction to the hearing date with the criminal case. Do you want to do that? I'll set it with the criminal case. All right, I think that concludes our interpreter cases for this morning. We have Josue Sepulveda Zuniga. Sir, you're here today on a charge of vehicle prowling in the 2nd degree and also a violation of a Pasco Municipal Court order, domestic violence. Each of those are criminal violations. If convicted of either one, you face up to 364 days in jail and a $5,000 fine. There is no mandatory minimum sentence for either conviction. However, a conviction for the violation of a domestic violence no contact order would result in the suspension of your right to possess, own, or control a firearm unless your right is restored by a court of record. Do you understand that? You do have a number of constitutional rights that were played before court started. Were you able to hear and understand those rights? Do you have any questions about those rights? You have had a chance to talk to the provisional attorney today, and after doing so, you've indicated you wish to plead not guilty and request the court appoint an attorney. I will enter a plea of not guilty on your behalf. will appoint Mr. Libbert to represent you. I believe he currently represents you on another matter. So he will be appointed on this matter as well. Just a moment, please. Mr. Rio, conditions of release in this case?
And I'm going to ask the court to impose that he have no criminal law violations, that he appear for all court dates, that he follow all no contact orders. Although I don't have much faith that he'll do that. This is the second one in a month, roughly. I'm going to ask the court to set bail at $3,500 bond or cash. He's also on probation for domestic violence out of this court in the case where this order stems from. And in that case, there was a violation of court order at that time. So we are concerned that he won't follow the court's orders.
Mr. Huey, conditions?
I know he's anxious to address the court. I did read the probably last statement of both cases. I would caution him, my advice to him is to not talk about the facts of the case. I think that's what he's anxious to tell you about. He disagrees with a lot of the facts of the case, probably last statement. Given that he's 23 years of age, he's been in the Tri-Cities his whole life. He works at a winery currently. I did go through his criminal record. That he would like to get PR so he can get back to work. So go ahead and address the court. Don't talk about the facts of the case.
Mr. Sepulveda, I will tell you this. The first mention you make of the facts of the case or wanting to argue whether this is true or not, your statements are done. When considering conditions of release, I do look at criminal rule 3.2 that directs me to review future appearance factors as well as showing a substantial danger factors. This case, there's an outstanding violation of a no contact order from July 27th of this year. This alleged violation occurred on August 23rd. As Mr. Rio indicated, you are on probation for a prior violation of the Pasco Municipal Court order and continue to be supervised by probation in that case. Some of the conditions of release or conditions of probation include following the court order. Here we are a month later, Mr. Sepulveda, and you're back on a violation of the Pasco Municipal Court order. I look at the facts and they're very similar to the facts from earlier, in that you're back at the family or your family's business where your brother works and you've been ordered not to return there. I'm not going to talk to you about the facts of the case. I'm telling you the reason why I'm setting some conditions on your release here. You continue to violate the no contact order. In one case, in the vehicle prowl, you were there inside vehicles and it shows you on a video doing so. I think both for your inability to follow the directions of the court, your prior warrant history on the other cases from Pasco Municipal Court from earlier this year, as well as the ongoing violation of the court order. I think bail is appropriate. I'm going to set bail in the amount of $1,500 on the violation of the Pasco Municipal Court order. I'll not set any bail. I'll release you on the vehicle prowl. The conditions are that you're not to have any criminal violations or incidents. You're to abide by the no contact order, not to have any domestic violence related incidents. I think your next court date is August 31 with Mr. Libbert. Even though that's less than a week away, I will set this for August 31 as well. We'll provide you with his contact information, and I'll ask the court to be sure we notify Mr. Libbert of this case, that it will be added to Monday's docket. The last one we have on this morning is Seth Berry. Mr. Berry, you're here today on a charge of simple assault domestic violence. That is a gross misdemeanor. If convicted, you do face up to 364 days in jail and a $5,000 fine. There is no mandatory minimum sentence for such a conviction. However, a conviction would result in the loss of your right to possess, own, or control a firearm unless your right is restored by a court of record. Do you understand that? You do have a number of constitutional rights. Those rights were played before court started. Were you able to hear and understand those rights? Do you have any questions about those rights? You have had a chance to talk to the provisional attorney today, and after doing so, you've indicated you wish to plead not guilty and request the court appoint an attorney. Is that correct? I will enter a plea of not guilty on your behalf and appoint Mr. Libbert to represent you. Conditions of release.
And I'm going to ask the court to impose that he have no criminal law violations, that he appear for all court dates, that he have no contact with the victim, and ask you to enter a no contact order. We were here just a week ago and the court set conditions. In that case, he's alleged to have held the victim down and covered her mouth because she was screaming for help. Here we are now. She's overheard on 911 saying, "My boyfriend's hitting me." There were allegations that he hit her multiple times. I'm going to ask you to impose a no contact order and set bail at $2,500 bond or cash.
Mr. Huey.
I did go through and I actually represented him at the last custody arraignment in August 17th. We did talk about the no contact order. Who's going to agree to a no contact order because this particular incident did not want it. Particular surprise matter that they stay apart. He has been in the tri-city for the last 10 years. He works for DoorDash. He doesn't have any criminal violations himself. He's last two incidents. It's a relationship pretty volatile. He will stay away from her as the case is pending. He is hoping for her.
As I indicated, I have reviewed the affidavit of probable cause. I do find probable cause. I have entered a plea of not guilty. I'll set the following conditions. Bail is set in the amount of $750 cash or bond. If you post that bail, you're not to have any criminal violations or incidents. I am going to issue the no contact order. You're to abide by the no contact order. You are to contact Mr. Libbert within the next 10 days and maintain contact with him while this case is pending. That means make appropriate appointments with him in order to assist him on this case. You're not to cause, attempt, or threaten to cause any bodily injury to, assault, sexual assault, harass, stalk, or keep under surveillance a protected person. Do not contact the protected person directly, indirectly, in person, or through others by phone, mail, or electronic means, except for the mailing or service of process of court documents through a third party or contact by your attorney. Do not knowingly enter, remain, or come within 500 feet of the protected person's residence, school, workplace, or person. A violation of this order with actual notice of its terms is a criminal offense and will subject you to arrest. You can be arrested even if the person protected by this order invites or allows you to violate the provisions or the prohibitions of this order. Do you understand that? You were given an opportunity, Mr. Barry, a week ago, where you were both released on conditions that you maintain law-abiding behavior and have no criminal violations and no domestic violence-related incidents. And here we are, 7 days later, dealing with the same issue. We'll reset this matter to September 14th. Yes. And because you have a case on the 22nd, where it looks like it was originally set for the 22nd, you've applied for court appointments counsel. In this case, we've appointed Mr. Libbert to the other matter, and we'll set that to the 14th as well. Two years, unless modified by this court. You don't get it modified. Okay? At this point, no. You talk to your attorney about that. All right, that concludes our morning docket. We'll be in recess. Thank you, Mr. Rio.
Thank you, Your Honor. Have a good morning.
All right. Mr. Bell is here now, so we'll transition to the afternoon.